Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast 190, another mini milestone passed. Well, we've certainly not been lacking in newsworthy events recently, have we, since the last podcast I did? We've had the Biden victory, unless you're a rabid Trump fan. We've got news about 2 possible vaccines, so things are happening, aren't they? Anyway, likewise, the courts have been keeping us relatively busy, and I've got 2 cases I wanted to talk about, both of which deal with important issues, and one of which is a real heavyweight contest given the importance of the issues to be determined by the court. And then maybe as a reward for sticking with me, if we have time, we'll have a quick Netflix review on something I've been watching. Haven't done one of them for a while. Anyway, please don't forget, as usual, podcasts, it's on iTunes, it's the Mayer Brown website, YouTube, the Twitter feed, Nicholas ROBER11, and the links to the cases posted out there, and it's on Yahoo, Google Play and Spotify as well. So, first up, we have the case, the Independent Workers' Union of Great Britain and the Secretary of State for Work and Pensions and others. This is an extremely important High Court case which was decided about 10 days ago, which I wanted to talk about as soon as possible. In short, before I talk about it in long, the IWU brought a claim seeking a declaration through the now much maligned process of judicial review. Don't you just hate those do-gooding lawyers? And the judicial review was that the UK had failed to transpose fully 2 EU directives into the UK's domestic law. Both directives relate to health and safety measures. The first EU measure, which was allegedly not properly implemented, was the Council directive on the introduction of measures to encourage improvements in health and safety of workers at work. The Framework Directive, that's what I'll call it from now on. That's a 1989 directive. There was a subsequent Council directive made pursuant to the powers of the Framework Directive on health and safety, and that was the health and safety requirements for use of protective equipment for workers in the workplace, the PPE directive. Quick point of terminology, I'm going to talk about workers throughout this. Although in parts the court's decision is not entirely clear, I'm referring to so-called Limb B workers, i.e. those within the definition of section 230 brackets 3 brackets B brackets of the Employment Rights Act, which defines a worker as a Limb B worker if they're an individual who undertakes to do or to perform personally any work or services for another party to the contract whose status is not, by virtue of the contract, that of a client or customer of any professional business undertaking carried on by the individual, unquote. In other words, to be a Limb B worker, in essence, you have to have a degree of personal service, and the person you're working for isn't your client because it's your business. So the case raised two separate aspects, and the claimants had to win both of them to win overall. First, I'm going to go into this in more detail. They said that the Framework Directive and the PPE Directive, properly understood, meant that protection should be given to workers under that directive and not just to employees. Secondly, they said that in key respects, but notably not all respects, the implementing UK legislation gave protection to employees but didn't extend that to workers. As I say, the union had to win both points to win overall. As was recognised early on in the case, if this legislation had not been correctly implemented, then it had been unchallenged on the statute book since 1992. However, as the union pointed out, during this pandemic, it raises particular issues of importance to establish whether workers are entitled to certain levels of protection. So, as such, the issue remained and remains a very important one. Well, starting with the Framework Directive itself, I'm going to come to the relevant provisions, but let's start with the definitions section. Article 3 of the directive provides that a worker is any person employed by an employer, including trainees and apprentices, but excluding domestic servants. An employer is any natural or legal person who has an employment relationship with the worker and responsibility for the undertaking and or the establishment. So pausing there, you can see at once the concept that a worker has an employer is a slight disconnect in the use of English, where the natural sense would be that employees have employers and workers have organisations that they work for. Anyway, under Article 5 of the Framework Directive, there's an obligation to ensure the safety and health of workers in every respect related to work. Article 6 says that the employer is obliged to take measures necessary for the safety, health and protection of workers. Since the court decided English law did adequately extend this protection to workers, I'm not going to go through those provisions in any detail. But Article 8 (4) provides that workers who in the event of serious, imminent and unavoidable danger leave their workstation may not be placed at any disadvantage because of their actions. Article 8 (5) states that employers should ensure that workers are able, in the event of serious and imminent danger to their own safety and or that of other persons, and where their immediate superior responsible cannot be contacted, to take the appropriate steps in the light of their knowledge and the technical means at their disposal to avoid the consequences of such danger. So, the starting point was whether or not the reference in the directive to workers included workers and employees, in English law terms, or whether it was limited, or whether it could be limited solely to employees. The second issue, which I'll come on to in a few minutes' time, is whether or not the UK implementation of the directive in fact already gave adequate protection to workers as well as employees. The argument for the claimant, which I'm hardly going to do justice in a short podcast, was to point out that in other areas of the Framework Directive it was specifically said that employers' obligations to employees were as in accordance with national laws or practices. Article 3, the definition section in the directive, which applies in Article 8.4 and 8.5, was not framed in that way. In looking at the definition of worker, there have been a number of cases at EU level looking at what is meant by the term quote-unquote worker in various directives. Depending on the context in which it appears, the term worker can either have an autonomous basic definition, which applies across the EU in relation to the term, or it may be a term which is defined according to national law. Claimants in this case said that a worker in this context meant that the term should be defined broadly and autonomously. The definition referred to any worker employed by employer, which was expansive language. Moreover, a purposive approach should be applied, they argued, given the nature of the directives, i.e. protecting health and safety. Since the definition of worker does not refer back to national law norms, an autonomous European-wide definition should be applied. And based on previous case law at the European Court level, the key feature of the relationship for an individual to be a worker within that autonomous definition was that for a certain period of time, quote, the person performs services for and under the direction of another person, in return for which he receives remuneration, unquote. In this case, the court accepted there was no single definition of worker in EU law, and it varied according to the directive. However, in certain circumstances, it was correct to note that there was an EU-wide definition of worker to be applied. It was clear from both the terms and the case law, and the terminology used in other language versions of the Framework Directive, that where the Framework Directive referred to employment or employee, this is not necessarily synonymous with employment and employee as defined under English law. This goes back, I think, to the point that I made earlier about it being an odd use of English for a worker to work for an employer. Alternatively, the court said if there was no single meaning to the word worker, member states could, by defining worker narrowly when they implemented it into national legislation, cut down on protections from individuals who would benefit from having those health and safety protections. So the court accepted the definition was not one, in this case, which varied according to national law, but had a minimum level EU-wide. However, under the directive, all we know about the definition is that the definition excludes domestic servants, and that an employer had to have responsibility for an undertaking or establishment. But putting this all together, the court decided that what it called the autonomous EU law definition of a worker applied, i.e. a person performs services for and under the direction of another person in return for which he receives remuneration. On that basis, those who are entitled to protection under the Framework Directive and the PPE Directive, which contain the same terms, were, in the opinion of the High Court, those who were covered by the autonomous EU-led legal definition, apart from domestic servants. So, claimants are over the first hurdle. How did they do on the second hurdle? They had to then show that English law had incorrectly implemented the directive. Now, Pausing there, you might think this is a blindingly obvious point, given the parties were arguing about whether or not the directive applied to workers in the first place or just employees. If the Secretary of State was happy to see that workers were already covered adequately, they'd hardly have spent time contesting the point the directive did not apply to workers. Anyway, of course, that's not the way the law works. So the court then had to go on, having considered the first issue, to consider whether the way the law had been implemented in England and Wales meant that workers covered by the autonomous EU definition were already adequately protected. Bear in mind, of course, that we know that some of the health and safety obligations under the Health and Safety at Work Act 1974 are expressly extended to workers, and that's why the court accepted that Articles 5 and 6 of the Framework Directive, which I mentioned briefly at the start of the podcast, were already adequately implemented by Section 3 of the Health and Safety at Work Act, for example. However, the bulk of the battle took place in relation to Articles 8.4 and 8.5, which I summarised earlier on. Turning to look at English law, under Section 44 of the Employment Rights Act, a right was given to employees not to be subject to any detriment if there were circumstances of danger which the employee reasonably believed to be serious and imminent, and which the employee cannot reasonably be expected to avert, not to suffer any detriment, and similarly, in circumstances of danger, if the employee takes appropriate steps to protect himself or other persons from that danger, the employee should not suffer detriment. This is limited to employees. There is no equivalent protection for workers. Now, there is a right which provides protection on employees and workers where the worker has made a protected disclosure. So, for example, a worker who's made a protected disclosure that there is a circumstance of imminent danger is protected for having made that disclosure. But the claimants pointed out there is an obvious and apparent gap in the protection once it's established that the Framework Directive requires protection for workers. Articles 8.4 and 8.5, which require protection for workers who take appropriate steps in response to serious and imminent danger. Well, that protection isn't replicated by Sections 44 or Section 100 of the Employment Rights Act. It's very easy to imagine a circumstance where the worker has made no disclosure but is seeking to avoid serious and imminent danger. Under Article 8, the directive does not require the worker to have made a disclosure first in order to obtain protection. As the court put it, the whistleblowing protection, which does apply to so-called workers as well, is concerned with disadvantages imposed on workers because of what they said. It does not protect them if they've done something to protect themselves from serious and imminent danger. Therefore, according to the High Court, Lim B workers have been wrongly deprived of statutory protection, enabling them to take action to avoid serious and imminent danger, either by taking appropriate steps or by absenting themselves from work. And the court likewise concluded that the PPE directive applies to workers too, and so in circumstances where employees were entitled to have PPE protection, so were workers. It's immediately apparent this is a really important case. It's not yet clear whether it's going to go on appeal. The losing party, the defendants, asked for more time to consider whether or not they wish to appeal, and that was granted by the court. Subject to that, however, the IWU have won a stunning victory to extend the protection for workers so that it is equivalent to the protection for employees in circumstances of serious and imminent danger, and to extend to them the right to have PPE equipment provided. Now, you might ask yourself why in the middle of a pandemic the government set its face against protecting workers in circumstances where legislation is already there to protect employees and it's trying to save the economy and protect the NHS. You might suggest that workers' lives matter every bit as much as employees' lives, but for whatever reason they elected to fight this case. Now, having elected to fight the case, it's going to mean, subject to appeal, that PPE equipment has to be provided to workers in all circumstances where it be provided to employees. Moreover, it's going to mean that employees' right to be protected from adverse action if they take appropriate steps in the absence of an immediate supervisor, or employees, workers who leave their workstation or a dangerous area will now have the same protection that employees would have under English law. However, one point to watch is that under English law, in fact, the legislation goes slightly further than is required by EU legislation, by the Framework Directive. The Framework Directive talks about taking action in the event of a serious, imminent and unavoidable danger, whereas the English legislation respective employees provides that employees are protected if they reasonably believe there to be a serious and imminent danger. It's going to be interesting to see if the government tries to implement any changes in legislation in the most grudging way possible. One would certainly hope not. So this case sits alongside the struggles of, for example, Uber drivers and others to have their worker status recognised by the companies they work for. So the stakes in those cases just got even higher. So the next case is Alta Trading UK Limited and others, and Peter Bosworth and others. This case is a very definition of a legal odyssey case. Sir Michael Burton, the High Court judge determining this particular application, commented, the case was coming back to him 5 years after he'd last been involved in it, and after it had then gone to the Court of Appeal, the Supreme Court, the European Court of Justice, and back to the Supreme Court, all just on the preliminary issue of which country or jurisdiction to determine the claimant's claims for conspiracy and fraud. I've dealt with this case in an earlier podcast, but the assertion, which is yet to be determined, is that the defendants who included directors of the company, have been guilty of conspiracy and fraud. The allegations are denied, and as I say, the issue is still to be determined. But the case is still only considering where the claimants were entitled to bring claims against the defendants. The point, in essence, in this case at this point is quite a narrow one. Under the Lugano Convention, the defendants were entitled to be sued in their country of domicile, which would have been Switzerland, if they were employees, as defined under the Convention, and they're being sued in their capacity as employees. So, if they're employees, then Switzerland. Otherwise, the Lugano Convention would mean that defendants could be sued by the claimants in England and Wales, which is where this litigation has been started. At the point at which the case was originally in front of Sir Michael Burton, the claimants wanted to sue in England and Wales, and to do that they conceded that they would not bring any claims relating to the contracts of employment under which the defendants worked. It was accepted by the claimants at that point that the defendants were employees, so the Lugano protection applied. Sir Michael Burton held that they could bring the remaining claims because these did not depend directly on the individual contract of employment, and so bringing those claims was in line with the Lugano Convention. But by the time the case went to the Court of Appeal and then the Supreme Court, the claimants took the view that the first and second defendants were not in fact employees within the terms of the Convention, and that concession was withdrawn. The issue as to whether or not the directors were employees, as defined, went to the European Court of Justice. This ruled that a contract between a company and a natural person performing the duties of directors of that company did not create a relationship of subordination between individual and company, and could not therefore be treated as an individual contract of employment. This applied even if the shareholders of the company had the power to procure the termination of that director's contract. But, subject to that limited control, the director was able to determine, or does determine, the terms of that contract, and has control and autonomy on over the day-to-day operation of the company's business and the performance of his own duties. In short, in my terms, if the running of the company is done by the individual or individuals, largely in an unrestricted form, the mere fact the shareholders have the right to vote on bringing the contract of employment to an end does not by itself create a relationship of subordination. Well, the matter went back to the Supreme Court to decide whether or not there was sufficient subordination here. It took the view that it needed to be referred back to the High Court to determine whether the directors were in a relationship of subordination. Now, it was agreed that the claimants had the burden of showing that they were entitled to bring the claim in England. Sir Michael Burton set out the process which he understood was to apply to determine the issue. First step is for the court to decide, if it can, who has the better of the case. If the defendant shows he has the better of the case on jurisdiction, i.e. the better or stronger arguments, then the claimant fails. If there is issues of fact in connection with that assessment, the court must take a view of the material available to do what it can to reasonably assess the facts. But if no reliable assessment can be made, the claimant establishes jurisdiction if there is plausible, albeit contested, evidential basis for the jurisdiction being, in this case, in the English courts. If there is an issue of fact in connection with that assessment, the court must take a view of the material available to do so, if it can reliably assess those facts. But if no reliable assessment can be made, the claimant establishes jurisdiction if there is a plausible, albeit contested, evidential basis for the jurisdiction in question. But if the defendant has a more plausible evidential basis, then the claimant fails. Here, therefore, the issue as to whether or not there was a plausible case was whether or not there was subordination of the individual director defendants, or were they, in my terms, effectively running the show. The parties produced competing schedules, which the court described as very contested and untested evidence. The court accepted the defendants between them did have power over the Arcadia group of companies, who were the group of companies allegedly defrauded. The court accepted. The court referred to a comment in an earlier case that the role of subordination was not shown if the directors had a sufficient power to influence in a non-negligible manner the persons normally competent to give them instructions and to supervise the implementation of those instructions. So the task, according to the court, was to set the claimant's evidence against that influence and supervision by the directors, against the rival evidence, I should say, for the defendant, against control and in favour of subordination. But the judge was satisfied the claimants had a good arguable case, the defendants had a more than negligible ability to influence the Arcadia companies and the instructions given to them. So on that basis, the claimants can, subject to what I suspect is an inevitable appeal, proceed in the English courts. Clearly the circumstances in this case are extreme. Nonetheless, issues relating to jurisdiction are far from unusual in employment law. It often comes as a shock to English employment lawyers and HR professionals that in many countries in Europe, senior directors are excluded from standard employment law protections, contrary to the approach taken here. Directors who live and work abroad and who find themselves in a dispute with their employer will have less protection in jurisdictional terms as a result of this case. The requirement to sue individuals in their country of domicile, rather than the country where the individual is employed, for example, can offer substantial protection for the employee. That's why it's in the convention. Added to that findings in the decision in this case, the decision in this case, that it's not necessary to prove lack of subordination. It's necessary to look at whether there was a plausible case as to lack of subordination, with a further then weighing of that plausible case against the defendant's plausible case. Well, that weights the scales more in favour of the employer if it is looking to establish jurisdiction where it is based rather than when the employee is domiciled. It reminds me in a completely different area of the test for interim injunctions under the American Cyanamide test, where there's similar dispute, maybe highly contested facts. How is the court to decide whether or not to grant an interim injunction? Obviously, of course, with cyanamide, you have the cross-undertaking in damages, which offers a degree of protection to a defendant who is being sued. We don't seem to have anything like that here as yet. Of course, the rules on territorial jurisdiction for UK employers in relation to the EU are being shaken up, although if we rejoin the Lugano Convention, I think we'll be exactly back to where we are at present with this case. One thing's for certain, these issues are not going to go away, and so an awareness of where you can sue employees, or directors I should say, is extremely important. So those are the cases for this episode. Thank you very much for listening. Oh, I promised you a quick cultural review. I'm not sure it counts as cultural, but anyway, in these days of doom and gloom and despondency and the night's drawing in, etc., a good escapist box set is worth its weight in gold. And there's a terrible pun in that, because I was going to recommend Money Heist. I'm a little late to this, I admit, but all 4 seasons are highly entertaining. It's on Netflix. It's great escapist stuff. And yes, some of the plot lines may be stretching credibility. But it's quite fun watching the way the programme walks the line, allowing you to retain sympathy for the gang, even as they're breaking the law. And if you too have been puzzled by some of the demonstrations that you may have seen recently in London or other cities with protesters wearing Salvador Dali masks, it'll all be explained in Money Heist. Mind you, the biggest debate around our house was whether it was to be watched in the original language with subtitles or in the dubbed version. I think anyone who watches it in the dubbed version, well, I don't know, crime against humanity in my view. So there we go. Thank you very much indeed for listening. I hope everyone's keeping well and safe, and I'm looking to do another podcast relatively quickly. So keep an eye out for that, and stay safe in the meantime. Thanks very much. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.